not generous, not to be confused with Ellen DeGeneres. And welcome to the Oregon Daily. Today's special guest was supposed to be Kim Jong-un, but unfortunately, he couldn't make it. Like that's an excuse. Welcome instead, Kate Brown, governor of this vibrant and booming economical state.
I'm Kate Brown, and I'm so excited to be here.
Our top story today is on net neutrality. Net neutrality is the principle that internet service providers treat data on the internet equally and not discriminate or charge differently by user, content, website, platform, application, type of attached equipment, or method of communication. This means websites like Google can't work faster than, let's say, the AOCwellnessblog.weebly.com. Check it out. All websites run at the same speed, limiting the ability of large corporations to control internet speed. January of 2019, Oregon will have its own net neutrality law.
This year, I, Kate Brown, signed a bill aimed at blocking internet service providers like AT&T and Comcast from throttling internet traffic. This was in response to the FCC, the Federal Communication Commission repeal of the Obama-era net neutrality rules.
But wait, I'm a Fed. That contradicts Article 2, Section 6 of the Constitution, the Supremacy Clause. It allows for federal constitution and federal law to establish precedence over state law and constitution.
Actually, it doesn't. The article specifically prohibits states from interfering with the federal government's exercise of its constitutional powers. However, passing the net neutrality law doesn't specifically interfere with the federal government's ability to exercise the constitutional law. There are no constitutional laws that specifically indicate restrictions on internet usage, so the power is left up to the states.
Oh, well, the federal government is going to be sure to have the FCC include a provision blocking states from creating their own net neutrality rules. This will make Oregon almost certain to face legal challenge.
On another note, when discussing the issue of net neutrality, Oregon state government reserves the right to interstate commerce laws. According to the Commerce Clause, Article 1, Section 8, this means that unless the use of net neutrality affects interstate internet usage, the federal government won't be able to interfere with intrastate law. In fact, Oregon's net neutrality laws end up affecting commerce and financial transactions between states. The federal government will then be able to interfere.
Well, that's because of the implied powers of the government. According to the elastic clause, we'll be able to pass unspecified laws, necessary and proper for the exercise of expressed powers.
Any laws pertaining to alcohol are a big deal. What are Oregon's restrictions on the possession and consumption of alcohol?
Well, the 1884 National Minimum Drinking Age Act, set in Title 23 of the U.S. Code, Section 158, requires that states prohibit persons under 21 years of age from purchasing or publicly possessing alcoholic beverages.
Actually, in Title 37, Section 471.410 of Oregon law, states that a parent or guardian may make alcoholic liquor available to any person under the age of 21 if the person is in a private residence and is accompanied by them. So, take that. You can drink, just with permission from a legal guardian, and responsibility.
Thank you, ladies, for your contribution to the topic. For those who are preparing to buy and sell alcohol for the next year of festivities, it's on every one of their minds.
Well, this is one of the topics that I know best. You, singular Fed, cannot do anything about our alcohol distribution. The 21st Amendment allows states to either permit or prohibit importation or sale of alcoholic beverages within their borders.
That may be true.
Oregon is an alcoholic control state, which means the sale of liquor and spirits are state controlled.
But the moment any of the sales go out of state, the Commerce Clause allows the federal Congress to regulate commerce among the several states.
But we're not talking about that.
But maybe you are.
The last depressing topic for discussion is capital punishment. So tell us, Governor, what's the status of capital punishment in Oregon? It's a highly debated topic. Are you implying that you don't know, Governor?
I'm implying that it's a sticky situation. You see, Oregon has had mixed feelings about capital punishment from the very beginning. The death penalty has become law in Oregon 4 different times. Ballot Measure 7 in 1984 made it so the death penalty was only for aggravated murder. Basically, the Oregon Constitution states that it's illegal, but the Oregon law states that it's legal.
How does that... You're contradicting your own laws.
That doesn't make any sense.
A lot of things don't make sense, Fed. But good news, not a lot of people get the penalty. But I mean, our people are still very touchy on the subject.
Okay. Let's take this back now. Y'all are make sure everyone understands that just through law, through Oregon state crimes, not federal crimes. According to Article 3, Section 2, Clause 3 of the Constitution of America, says that that states can control punishment types for crimes committed in their state, but if a person commits a federal crime, then the punishment is delivered under federal jurisdiction. In this way, capital punishment is a concurrent power. Through federal government, death penalty is completely legal. It's used in cases where a government official was murdered, a kidnapping that resulted in death, running a large-scale drug enterprise, treason, and such. A famous example of federal capital punishment is the Ethel and Julius Rosenberg, who were spies for the Soviet Union, who were executed in 1953.
Oh, those Soviets.
There's revisions too federally for this. The Supreme Court in 2002 prohibits death penalty for mentally challenged criminals, and in 2008 the court decided that the penalty could not be used in state cases where the defendant did not commit murder.
Fascinating.
There's nothing else.
Thank you.